Good morning, everyone. This is David Taylor, and I'm an attorney with Twin Falls Estate Planning. And are you playing musical chairs with your family and finances? Just always hard to know what to title these. If I title it estate planning, you're going to think it's a lecture. It kind of is a lecture, but I think it's an important one. And we're going to go over quite a bit today and learning about what estate planning is. Probably the most important question we answer is, do I need an estate plan? What are options? What are prices? We're going to go through everything today. And just a few things as far as housekeeping goes. There is a Q&A for you to be able to ask me some questions. You can ask me questions at any time during this presentation if you just want to drop them in the chat, or if you want to raise your hand. We'll make sure that we see it, and we'll answer your questions as we go along. And if nothing else, then at the end, we'll make sure that we have time to answer any open questions, just in case you are saving one for the end. So with that, we'll go ahead and just a few things. Of course, being an attorney, you have to give the typical disclaimer that what you're about to see is an educational experience meant to guide you into determining whether you should create an estate plan. And of course, this is not legal advice. Legal advice requires an engagement letter, facts, and I'm not your attorney yet, so just use this information to help get your family in the right direction, or also to score some points at the next bar trivia night. So that's just my little disclaimer there. And a little bit about me. I grew up in the Boise area and a huge Boise State fan. I lived there for quite a few years, and my wife was from here in Twin Falls. We were married here in Twin Falls, and we pretty much lived in Boise for the majority of our marriage. We had two children who were born a few years ago. They are twins. They are boy-girl twins. They started kindergarten, and so we're just adjusting to life with kindergartners and having a quiet house, but that's a little different. In any event, we moved here to Twin Falls a few years ago, and this is a picture of our family here in front of the Perrine Bridge, and we love it here in Twin Falls. So a little bit about my professional background. I think it's important for you to understand where I'm coming from on this, because I've had some experience in a few different areas of law and seen a few different ways that attorneys do estate planning. And I eventually went with this way for a reason, the way I do it. It's a very modern approach to estate planning. Many attorneys just kind of sit and wait for their clients to come to them. Or they get clients who have referred clients to them, and leaves some of us without accessibility to the law. In other words, this is why I do this, is I like to educate, because I find there's not a lot of attorneys who go out there and educate. And you'd be amazed at how many people come into my office during their first visit. And one of the first things they tell me is, David, we didn't learn this in school. Why didn't anyone teach this in school? And that's a great question. So that's why I put this out there, because I know the things we're going to talk about today, you didn't learn in school. So how I came up with all these ideas is I actually interned at an estate planning firm kind of on a whim. Back when I was in law school, I knew a lifelong friend. His name is Mark White. He has an estate planning firm over in Eagle, Idaho. And he taught me, I guess you could say, he taught me the tricks of the trade and how to run an estate planning firm. And I thought that was how we did estate planning as attorneys. And when I was done with my internships, one of the things that he told me was that I need to go out there on my own, and I need to learn how to be a lawyer. I need to go to court, and I need to make lawyer noises. And so he said, I'm not going to give you a job here. You need to go out and discover on your own what you want to do with your life. So I did, and that's when I took a job here in Twin Falls, and I was shocked to see the way that the traditional attorney practices estate planning. So again, I was at a firm where that was all he did was estate planning and some other areas of law related to that. But I was amazed at a couple of things that I saw. For example, whenever a client would come to do an estate plan, they take down some information and then they go back to the last will or last plan that they did and change the names. And I was appalled at that. There was no education. There was no discussing options. It was quite literally sit down, get some names, and run with it. And I don't mean to, make any individual attorney look bad. That's just what attorneys are trained to do. We are trained to solve a problem. Okay, so when someone comes to see a traditional attorney and they say, hey, here's my problem is I'm going to die, and I want to make sure my property goes to the right place, the attorney looks at that and says, that's easy. You know, we just put together some legal documents, and that's all that needs to be done. And that's about it. Probably about 2 visits. They get the names, and then they have you come back in to sign, and then they never see you again. Why is that bad? Well, let's start with this: is things change. You know, your plan changes, your life changes, your family dynamics change, and so it just didn't seem to work, because I would have multiple you know, plans that were done come to me and try and administer them, and something had changed, and you just felt bad because they should have come to see us and make a change, but they never did. And one of the worst things is I talk to some people and I say, hey, which attorney did this will for you? And they're like, I don't know. They didn't even remember who their attorney was. You know, there was just no relationship. It was a very much a document driven system, and that to the traditional attorney is how it worked. But the absolute worst part about it what was that when the family needed help, because eventually, you know, we do a plan, and eventually that person is going to pass away, and when the family would come to see us, they'd say, hey, yeah, mom and dad got their plans done from your firm some 10 years ago, and they told us everything was taken care of, but we went to the bank, and we gave the bank all of the documents that your firm did, and the bank said, we still need to go see you to go through this thing called probate. We don't know what that is. And so basically I would have to tell these clients, well, you know, we did do a plan back then, but it was only a roadmap for what needs to happen next. And what needs to happen next is you need to pay us thousands of dollars so that we can administer your affair. And as you can imagine, that was not well received. The family's under the impression it was all taken, and it wasn't. So I decided to start a firm where my focus is not so much on the documents. The documents are a byproduct of the work I do, of course, but my focus is ultimately to make things easier for loved ones. And primarily we plan for incapacity and death. And so that's why when I talk about education is I give the education to the clients, because we make a plan based upon what concerns you, and how we can make things easier for your family. So with that, just kind of curious, you don't have to worry about chiming in if you don't want to. I'm just curious as to why those who came today. Maybe it's because you wanted to have the total assurance and comfort of knowing your family was going to be taken care of if something happened to you. Or maybe you care about your stuff. You know, maybe you want to make sure your assets get to the right place. You've worked hard for it. This is kind of a funny one, because a lot of people, when I say estate planning, you know, they look at this and say, oh, you know, it's my stuff. I don't care what happens to my stuff. I'm dead. And that's usually the husband, like, I don't care. I'm dead, whatever. But some people are concerned. Some people have worked hard for their life, and they want to make sure their assets go to the right place. They want to make sure their assets are protected from creditors, predators, divorce, and we'll talk about that a little bit more, but you can protect your assets from some of the perils of the world. Or maybe you're concerned about incapacity. I get incapacity concerns quite a bit. Estate planning is not just about what happens to your stuff when you pass away. Estate planning is also what happens to you. And you know, we're going to talk about estate planning a little bit more, but that's one of the main areas of focus that I have is incapacity planning. And because there might come a time where you're not able to think for yourself. And we'll talk about that a little bit more, but you can put together a few documents and a plan, and you can avoid the court hearing. So I'm going to say this now. I'm one of those few attorneys that I hate court. I don't like going to court. I'd much rather resolve things outside of court. And I can tell you, not many attorneys will tell you that. Many attorneys love to go to court. They are the tall, dark, handsome, slick talking, you know, and that's not me. I'd rather stay out of court. And with many of the documents people do with the attorney, with the traditional attorney, court is still inevitable. And that's because the attorneys think, yeah, this court proceeding's not so bad. Well, we'll talk about that in a minute. But as you can tell, I'm not your traditional attorney. So if you came in here for any of those reasons, then you're in the right place. I want to empower you to be able to make an informed decision for you and your family. Is this the right choice? Should you get an estate plan? What happens if you don't have an estate plan? Do we want to make things easier? You know, is that worth it to us to do that? So I have a quick question, and we don't need to take out the voting devices today. This is a little bit easier when I could present in person and see everyone's hands raised, and I do miss that, but these are the times that we live in, right? So, trick question is, do you have an estate plan? And I often ask this when I'm presenting in front of many people, and I'll get maybe less than half of the hands raised, yeah, we did a will, or we did a trust, or we did something. But the actual answer is you already have a plan done for you. And we're going to talk about that a little bit more. But even if you don't do a will or a trust or anything, the government has a plan for you. And it's through this process called probate or guardianship. And we'll talk about those a little bit more. But I want you to understand that even if you walk out of this webinar and just be like, yeah, that Dave is crazy, you still have an estate plan, and it might behoove you to know what that estate plan is that Idaho made for you back in 1974 when they adopted the Idaho Uniform Probate Code. So let's talk about the basics of estate planning, and that will make more sense. What is estate planning? Estate planning is, let's start with this. What is an estate? We think that an estate is this Downton Abbey manor. It's really not. An estate is the stuff. You own a lawnmower and you have an estate. You could even be a minor child and you have an estate. You as long as you own property, you have an estate. Of course, people might have more, estates of more worth. Some people might have less. But as long as you own property, basically as long as you're a human being, you have an estate of some sort. And when we talk about estate planning, we are referring to creating a plan that governs what happens with your property. And what I mean by that is we typically determine what happens during the event of incapacity. Incapacity generally plans for two things: as incapacity relates to your finances and as incapacity relates to your health. So what happens if you get to a point where you can't think for yourself? We create a plan for that. And of course, the inevitable death. How does your property get administered? Who gets your property? What kind of options do we have? There are ways to eliminate or significantly reduce the administration cost when you pass away. And I hate to be the bearer of bad news on this, but there is a cost to die. And it's going to be different for everyone, but generally there is a cost to die, and there's options that you can prepay for that cost beforehand. So I'm going to go ahead and talk about that a little bit more. Sorry, switching screens here. All right, so there's two plans. There's the plan by default, and then there's the plan by design. The plan by default is the one I was mentioning before. That's the government's plan for you. So the government has a plan for everyone as far as it relates to incapacity and death. And generally that plan, it involves courts and judges and lawyers and attorneys. And it's just this pesky thing where the laws basically say that a judge needs to sign off on how your plan is going to be administered. Same thing if you are incapacitated. So that's the plan by default, and we'll talk a little bit more about that. And then there's also the plan by design. So the plan by design includes the documents to avoid these types of proceedings. So you have options to create documents to say, oh, I don't want this to happen. That sounds awful, and I would rather not have to go through all these court proceedings. So we have some of those options for you, and it usually looks in those documents that generally if you execute one or more of these documents, in particular a living trust, you can avoid all of those court proceedings. But that's why they're there, is because you set a path now rather than having a judge sign off on it. Let's talk about incapacity a little bit more as it relates to healthcare. And when I talk to people about healthcare planning, generally what I say is in every hospital, in every doctor's office, there's always what I refer to as an ethics committee. there is someone or some people behind the scenes, and they are calling the shots as it relates to your healthcare, meaning they say, well, looks like this person can act on their behalf. And what I'm talking about again is incapacity. You're at a point where you can't think for yourself. And what happens then? The ethics committee doesn't necessarily decide what happens for you. Maybe to an extent they do, but more importantly, they decide who can act on your behalf because you don't have any direction otherwise. And so we have to let someone else make that decision for you. So it's not a judge, but there is someone who you will never meet. And I've seen situations where people have come in. We got a call about a month ago, and what happened was this sister was taking control over her brother who was in a coma, and the hospital staff was no longer talking to brother's mom or even brother's child. And so mom and child were out of the loop, and the only one that the hospital was talking to was the sister. And what had happened there was the ethics committee, for whatever the reason, decided that the sister is going to be the one that we need to talk to and cut everyone else out. So without a plan otherwise, you're leaving it to chance, and you're leaving it to someone else. And some of the things I'm saying in this slide, as you can see, is I care a lot about this because money is fungible. That means that if you spend all your money, you go down to Vegas and you spend all your money, gamble it on Red 18, you're still going to live. You still exist as a human being, but your healthcare directives, if we get something wrong, you're not going to exist. And so I think that healthcare directives are probably more important than the financial directives, because we care about you and we want to make sure that that those go right. So the other thing that we plan for is what happens when you pass away. So when you pass away, there's a few mechanics to understand about this. Is again, there is a plan for you, and that plan basically says that as long as you own property, then there's going to be a court proceeding, in particular real property especially. And this is one where people get tripped up because they say, I don't have much. I get that, I'm with you, but according to the state of Idaho, if you own a home, doesn't matter what it's worth, right? You can tell me that you're upside down on your home. You can tell me that you own 1 square foot of land in Kimberly. It doesn't matter. Idaho law says that a judge ultimately has to sign off and approve how that property is going to be administered. And that's what probate is. Probate is, it's a lawsuit. It is a court proceeding, and the reason why attorneys make a lot of money off of it is because every move that you make, there has to be a court document filed, and it's hard to do it on your own. And that's why many people have to hire an attorney, because they're not sure, what to do. But the other thing that Idaho says is it also determines what happens with your property. And as you can imagine, it's about what you would expect. Is when one spouse passes away, everything gets left to the other. If you're unmarried, then everything goes to your children. If you're unmarried and you have no children, then it goes to your parents. We have a plan for what happens to your property. A lot of people will come to me and they say, hey, I want to make sure my property doesn't go to the government. Yeah, I don't blame you. That doesn't sound like a pleasant thing to happen, but it's kind of hard for the government to get money in this sense. There are some other ways the government gets money, and what I mean by that is, as you can tell, as long as you have parents, siblings, nieces, nephews, or even great-grandparents, great-uncles, first cousins removed, or whatever that is in the family tree, like, we're going to figure out who gets your property. That's not too much of a problem. The other problems are unclaimed property. So there is a potential that the government gets your money through the process of, we didn't know what your assets were. So you pass away unexpectedly, and your kids are left to, check the mail, check your email, or whatever it is, and try and find out what all you had. And there might be something like a life insurance policy that's sitting out there that they didn't know about. There might be a bank account over in the state of Washington that you set up years ago and you forgot about. And what ends up happening is that money goes to the government. Idaho has $30 million in unclaimed property right now. And then this is why I tell my clients that I want to make sure that we get all of your assets in one place. The other way, just as a quick aside, that the government can get your money is through what's called long-term care planning or Medicaid. If you end up, this is just a little tangent, but I'll get right back to it. If you end up on Medicaid, meaning you can no longer afford your long-term care, then the government has to pay for your long-term care, and the government wants every dime they spent on you back. So let's say you own a home for $300,000, you need Medicaid, and you pass away. I'm sorry, you need Medicaid, and so the government says, hey, yeah, we're going to help you out. And this sounds like Alex Trebek or something. You get to keep your home, and you get to live there, and we're gonna set you up on Medicaid. And you say, great, that sounds wonderful. Well, what they don't really tell you is that when you pass away, then every dime they spent on you, they're going to force the sale of the home and get it back. I've seen it in 6-digit figures. I've seen it as low as 4,000. The number is just, who knows what that number is, but that's what happens is you end up losing your home and the money goes to the government. Isn't that a wonderful thought? All right, so we're going back on track here. So here's the other thing with probate is it's expensive. And I mentioned this before because it's a bunch of court documents and it's hard to navigate. There's no real clear path. And even I try and give my clients a checklist, and I eventually stop doing that, and I take a more hands-on approach because I find even with the checklist you get lost. But basically every time you make a move, then you have to file something with the court. And there's some other things that are concerning about probate. It's not private. So when you go through probate, it is a court proceeding, and technically the records are on file with the court, and so everyone can see A, what you had, and B, what your kids got. Why is that bad? I don't know. You might have a slimy car salesman who starts going through the court records and calls your kids because the contact information is on there and says, hey, I noticed you got an inheritance. Come see me for a new car. And I hope you guys can realize at this point that I have stories for a lot of these things, but that has happened. The other thing about probate is it's about $3,000 for an uncontested case. It could be less, it could be more, just depending on the amount of work that goes into it. But there's multiple documents that have to be done, and every time an attorney touches those documents, that's a few $100s, and it's just not very pleasant. This is the conversation I have with folks, and it's hard. But many times, someone's passed away and they come in and see me, and of course they're like, what happens next? And I have to explain this to them, and I say, buckle up, because we're going to be very familiar with each other. And so this is what I mean by that, is I'm going to explain some of the mechanics a little bit more. And with this, we're also going to explain what a will does. So here's how probate works. So the first part is death, of course. So someone passes away, someone owns property, and the first thing that happens is someone, usually a child, could be a spouse, someone has to go to court and say, hey, mom or dad passed away, and I want to be the personal representative. And usually that requires getting some other people to sign off on it and say, yeah, we're okay with that person being personal representative. And every now and then it could be someone outside of the family, but ultimately Idaho has a law that says who can be the personal representative, and if you go against that, or even if you go with it and there's a tie, you have to get multiple people to sign off on it. And I can tell you, I don't know why this is, but sometimes this is the hardest part about a probate case, is just to get it into court. I had one case where this sweet lady met with me back in March, and she was not appointed until late July because one family member refused to sign any documents for whatever the reason. So that's the first step, is we have to first get that person appointed, and that person gets appointed by the judge to say, yeah, you can run the show. And that personal representative, then they administer your affairs in the same way that you would administer your affairs to wind everything up. Meaning they can sell your home, they can pay your debts, write checks out of your checking account. They can do all of those things that you could do. And the few things about that is That's easy. Here's where it gets hard, because I mean, that just makes sense, right? You're supposed to administer the fair. Yeah, we get that. Here's where it starts to get a little bit hard is there's an inventory. So within 90 days, the personal representative has to give an assessment of what the estate is worth and then file it with the court. We have to notify what I call the creditors and the beneficiaries of what you're worth or what's at stake. You know, what you're going to find, I jokingly say this, although it's true, is the government's plan is a one size fits almost no one plan. Because I have many people who come to me and they say, Dad didn't have any debts, Dad paid everything off. Great, I don't care. The law says we still have to do this for any creditors that could be out there. And not just that, but we also have to publish something in the newspaper that says so and so has passed away. You've probably seen those back when you know you're searching for the TV guide some 20 years ago. I don't know if those are even still in the newspaper, but you see some kind of legal notice section and it says so and so has passed away. Anyone who wants to make a claim against their estate, please speak now or forever hold your peace. Okay, that's what's happening is we get to notify the whole world that you passed away, and then you get to deal with the spam mail that comes from that when people saying, hey, sorry you passed away, let me sell your home. So that has to be done for 120 days, and after all of that, now we start administering your estate. We're very close to where we can hand out the property, except that there's this pesky law that says uh, in order to administer your property, we first have to wait 6 months. So we have to allow 6 months for the probate to be completed. We have to allow 6 months for the beneficiaries to say they object, or we have to allow 6 months for the creditors to say that they object. By law, it takes 6 months to administer your affairs. So that means for 6 months, your assets are locked up. And this is why when I sit down with the client, one of the things I tell them is to, you know, buckle up because we're going to be here for a while. And in fact, by about month 4 or 5, I start getting bored and I just call the client just, you know, for no reason other than to check in with them and make sure they're okay. Then after we get all that stuff, now we can start cutting checks and winding up things. So that's probate in a very long story short. And here's what a will does, because I often get asked the question, what's the difference between a will and a trust? And here's the answer as best as I can describe. A will directs the probate court. So right here, where I say a will governs personal representative and residuary, this is what I mean. If you write a will, you are saying who you want to be the personal representative. Why do we do that? Because that can simplify things. And then you can say, here's who I want my property to go to. Now, one of the most common misconceptions I hear is that I want to do a will so I can avoid probate. No, and this is why I think the legal education is important, because I can tell you that I've had people come into my office and they said, I got a will done by an attorney. And I say, great, did you know that you still have to go through probate? No, they did not receive this education. And so they were not able to make an informed decision. They thought that they were going to avoid probate with the will, but they were mistaken. But this is what a will does. Now, it's not necessarily a bad thing. You know, I still do wills, but that's what it does is you simplify the court proceeding and you give some directions for how you want things to be done and ultimately where you want your property to go to. So here's how you can get your estate plan done, but let me tell you just about the typical experience, because I think it's important to know what's out there. And again, this is what I did for some time when I was a traditional attorney. You know, it's like a one-time transaction. You get the form documents. Again, it was 2 appointments. You came in, we got some names, and of course you're a busy law firm, and you said, hey, in about 4 weeks we're going to get you back some names, and then what we would do is we would send the clients the entire estate plan and say, read your estate plan and get back to us when you're done and let us know if you have any questions. And there were some times where a client just ghosted us at that point. You know, people look at them like, I'm not going to read that anytime soon, or yeah, I'm going to read it. I used to have to hound people and say, hey, have you read your documents yet? No, I haven't. Well, you were the ones that came to see us, and now you're having some some issues reading your documents. May avoid probate. It just depends. It really takes a hands-on approach to avoid probate. I mean, I can tell you now, I know there's documents online. I know there's cheap ways to get this done, but I'm telling you, if you want to get things done and make it simple for your family, really need to see an attorney who specializes in these things. Because you can see online, hey, get your trust done, completely done for $350, and if you really think that's going to get everything done and avoid court and conflict, the chances are you're wrong. It could work. I've seen a will that was handwritten, and we took it to probate, and it was a letter from a brother to his brother, and he said, hey, if something were to happen to me, here's what I want to have happen. We went through probate, and it was just fine. But on the other side, I've seen it also where someone did their own estate plan, and I charged, I think, more than $2,000 than I would normally charge any other person. We ended up taking 8 to 9 months. We took about 8 months longer than it normally takes, and the property still didn't go to the right persons when everything was said and done. So it's a chance. It's a risk that you're taking. You see an attorney to get the ongoing legal guidance, and the other thing is the potential loss of property to the state of Idaho. One of the most important things I think that needs to be done is to get all of your assets in one place. Don't depend on your kids checking your emails or checking your mail. Things just have a tendency to get lost. Some of your companies are only going to send you an email or a letter once per year, and your kids might be done with your affairs before that time comes. So here's the new experience, and this is a very modern approach on estate planning, is to make an informed and empowered decision. Going back again, it's the education. It's telling you, hey, here's what your assets are. Here's what happens if you are incapacitated. Here's what happens when you pass away. Are you concerned? Yes or no? Yes, let's talk about prices and options. No, see you later. I have had people come in and I explain what it looks like, and they're just not concerned. Okay, at least there's a value in knowing what would happen to your family when something happens to you. Save your family thousands of dollars. The whole point of a trust-based plan is to reduce cost upon administration. Going back, I know I was talking about what's the difference between a will and a trust. If you set up a trust-based plan, you avoid probate completely, as long as you do it right and as long as you keep track of your assets. The rationale being that you no longer own your assets. Because remember what I said in the beginning, if you own property, then Idaho requires you to go through probate. Well, if you set up a trust, technically you've set up an agreement, basically a contract that says your trust owns your property. Kind of a weird thing to think about. You can still do what you want with your property. You're under no obligations. You can still, take a match and light your house on fire if you wanted to, and whatever, you can still go to Vegas and blow your money. There's nothing restricting during your lifetime. But when you pass away, everything is administered outside of the court. And that is just a guarantee to lower your administration expenses. Have there been times when someone needed my guidance, even though they had a trust and they had to hire me? Yes. Was it cheaper than probate? Of course. And the reason why is because we don't have to file these pesky court documents every time we want to do something. We just go and we administer the trust estate based upon what the trust document says. And if there's a conflict, then we work it out between ourselves, and there's no judge involved. And that's the thing that makes it less expensive. Or in some cases, there's no expenses because they can administer it on their own. But in probate, you have to go in front of a judge every time you want to make an agreement. It's got to go in front of a judge. You want to transfer something differently than what the will says, you got to go in front of the judge. Whereas with the trust, the administration costs are less because everything's just going to be administered outside of court. Also with the trust, you can protect your money from the outsider. So this is a little bit more advanced planning. You can set it up so that your inheritance goes to their children, and it's their money, and they can do with it what they want, but that money is going to be protected from whatever perils may come later in their life. So say, for example, if your child ends up getting an insurmountable student loan debt. Maybe, heaven forbid, they have to file for bankruptcy, or, hate to say it, maybe they get a divorce. You know, that money that you set aside for them is theirs, but that money is going to be protected from the creditors and the predators and all of the perils of the world. Same thing with married couples. And again, it's a little bit more advanced, but you can set it up so the assets you leave behind for your spouse are protected from some of the surviving spouse's perils. One example is that being Medicaid. You can set it up so at least your half is going to be protected for Medicaid and not have to go to the government. It really just depends. As you can imagine, the more planning you do, of course, the more the cost goes up. But that's why we talk about those options. And that's one reason why I don't bill by the hours. I say, look, here's the starting price for your trust plan. Here's one $1,000 option. Here's another $1,000 option. You know, do you like these? And yes or no, is it worth it? But at least you can make that decision. You can say, yeah, David, you know, $1,000, that's not worth it to us. We're okay. Great, you know, you've made your decision. So ultimately, though, just as I say here down here, this plan does work. I'll tell you just one thing a little bit about my experience and my process. I put a lot of effort and a lot of resources into doing this right. Because let me tell you, the problem that attorneys have is we don't always see the direct results of what we do. I mean, you could in theory do a will 20 years ago, and then that person passes away and you realize, oh, there's an error. And what does the attorney do? You think, hey, you know what, going forward, I'm not gonna say that term because that caused a problem. But what happened within the last 20 years, you know, because you had a document with that problem. So what I did is I decided to work with other attorneys, and the concepts and the software and the draft and the documents that I use are the same documents shared by many attorneys. And it's not a form document, it's not a fill in the blank, because those don't work, but it's a process. And most importantly is it's a proven concept, because that way when one attorney sees that there's a problem or there's a change in the law, then we all adjust based upon that. And that's what gets us the best plan possible, and we know that it's going to work. Here's some other common techniques people do. So maybe you've heard this and said, you know, I don't know if I want to see an attorney. I sometimes call this poor man's planning. Some other ways you can make a plan is you can own property jointly. It doesn't always work, but what I mean by that is spouses, you know, it's a weird concept, but each spouse owns property as a 1/2 interest, meaning husband and wife. They don't just own a house as husband and wife. Husband owns 1/2, wife owns 1/2. And when one spouse dies, then the other half still has to be transferred to the other one. There are some ways that you can plan for that, but that does restrict you. It's this thing called joint tenants with right of survivorship. You can set it up so that when one spouse passes away, the other's half transfers automatically, but you are restrictive in that. It's harder to sell, harder to divide up your property. It gets a little tricky there. Designating a beneficiary. In theory, you could walk down to your bank and set up all of your accounts to be a payable on death account, meaning that you can say, hey, my savings account, when I pass away, it's just going to go to Bob. That's okay, but one of the biggest problems with it is that type of planning doesn't really call for contingencies. What if, and heaven forbid, Bob passes away before you? I am actually right now in the middle of a case where a guy back in the 90s set up a bank account, and he was told, since he was a single man, he said, hey, you should really put your girlfriend as a designated beneficiary on this account. You can probably guess where it's going. He broke up with the girlfriend and died, where are we at, 20 plus years later, and the girlfriend is the designated beneficiary in his account. And now we're fighting with her. And by fighting with her, I mean we're praying that she's going to be a decent human being and not take that money, because that's the way it was set up. So there's not a lot of contingency planning with that. Another technique that doesn't always work is signing a will. Let me tell you something about wills. Wills are easy to sign. And what I mean by that is, in Idaho, you can do what we call a holographic will. You can sit down and handwrite something that says, hey, I want this person to be in charge. I want my money to go here. Sign it and date it, and that's a will. You can also, like I said before, do these online. They're not hard to do, but as I mentioned a few slides before, the issue is that eventually that will is going to have to go through probate. And we're going to have to, quote unquote, prove that will in a court of law. And there could be some snafus there. But more importantly, I know attorneys who charge thousands of dollars to do a will. And admittedly, with my plan, some of those wills are some of my wills are expensive too. But then, I don't know if the people realize that there's going to be an added cost of probate later on down the road. And this is why I want to give that education to empower you. Some people, after hearing all this, still want a will. And they say, you know what, I'd rather pay a little bit less now, knowing I'm going to go through probate later. That's okay. At least you know. I just don't want you to be the one that says, oh, I thought we did this to avoid probate. Relying on a do-it-yourself trust schedule. So sometimes people set up a trust and they don't do it right. And trust is very complicated. So just a quick review. A trust is a document, a legal document you set up, and you basically say, hey, all of my assets are going to be governed by this trust. But it's complicated to link your assets to the trust. And what I mean by that is when you set up a trust, if you don't want your property to be governed by the state of Idaho, you have to rename your property to the name of your trust. And people commonly miss that step. And sometimes what they do is they just put a document in their trust that says, hey, all of these pieces of property belong to the trust. That doesn't work. You have to go and you have to retitle the documents to the trust. I had one guy come in here, 5 or 6 months ago, and he had a trust. This guy, bless his heart, owned a business, had quite a few assets, and he brought this trust to me. And he didn't understand when I said, yeah, you're still going to have to go through probate, and your trust document does nothing because your assets aren't linked to them. And he just kept saying, but I have a trust. And I had to say, you got diddly. The trust, drafting a trust, you could have the most beautifully written trust, so much to the point that years later after you die, that we're going to take it to the publisher and get it published and sell it for millions of copies because it was so good. But that doesn't matter because you have to then link your assets to the trust. And this is, in my opinion, where many do-it-yourself trust and where many attorneys fail, is they don't give you the guidance or the resources to link all of the assets to the trust. So a fully funded trust, these are the ways to avoid court. And I was mentioning this before, but you not only have to have a trust, you also should have a trust with disability provisions. So that's a plan for incapacity. And then you have to retitle your investment accounts, execute new deeds, sign a new signature at the bank, assign your personal property to it, change your life insurance. It just takes a few steps. But that's my job, is to guide you, or we charge a little bit more if you just want us to do that work. Some clients will just look at this and say, I'm too busy and it's worth it to pay you more to get this done. Whatever it is, either way, we make sure that all of this gets done, whether it's you doing the work or us doing the work. But the most important thing is to understand is it takes a few steps to get it done. Want to make sure your assets are protected completely. So we touched on this before, but in a trust, you can do some beautiful things with it. I've seen people set up pet trust, and what that means is they wanted to set up a plan to take care of their pets when they pass away. And I've seen people, of course, special needs trust is one. Special needs trust meaning a person is an individual with special needs, and they are on some kind of government benefit where they can't get an inheritance. And so we set up a special needs trust where they can still have some of that money. It's theirs, but it's not going to disturb their government benefits. We can protect assets from remarriage is an interesting one, and I like bringing this up to couples. It's a very weird concept, especially me. Of course, I'm married and have been for 11 years, and we have 2 kids, and very weird concept to think about. But there is the potential for your spouse to pass away before you, and an even greater potential, if that happens, that all of the assets you worked hard to do, you worked hard to earn, go to that new spouse. There's ways that you can prevent that from happening. And what I mean by that is, let's just give an example. Husband and wife were married for 30 years, and then, husband passes away, and course, has a will or a trust, whatever it is, that leaves everything to his wife. And wife then remarries, and she has a new husband, and again, probably in her 60s, 70s, something like that. And she doesn't do anything with her estate plan, or she, uh, even if she could just very well go back to her estate plan, just say, hey, I leave everything to my husband. Now, what you've done is you've cut off your assets from staying within your family, and you've given it to a new family, because what happens when that husband dies? All of the assets go to his children and his heirs. And so without some protections, and again, these are things that we explain and just find out what the, if there's a concern about that, but there is a possibility that the hard-earned family assets can go to a new family without some protections. So how do you protect your assets? And we talked about this, not giving money to the government, keeping an itemized list to make sure that we know. I tell clients that I want in their binder a spreadsheet. I want to see what your assets are. I want to see what your liabilities are. I just want to make sure that the kids can just pick up your binder and say, I know who to call. Yeah, these are all the people we need to call, rather than going through a shoebox, which is my parents, and I've been trying to convince them to get everything into their binder too. She said, oh no, we got everything in a shoebox. This is where it's, okay, well, yeah, not ideal, but better than nothing. At least put all your information somewhere so we don't get lost. So how do you get started? For my process, every client starts with what we call a family asset protection meeting. And I value that at $500 because there's a lot of work that goes into it. And it's a meeting that we block out 2 hours, but it's similar to what we talked about here. And I basically apply these concepts to their assets. And I say, okay, here's what the law says. Do you like it? Yes or no? No. Then let's talk about prices and options. If you're okay with it, then we'll go our separate ways, and all will be well. Price ranges, if you're looking at a will-based plan, that's probably going to be $1,000 to maybe $2,000. A trust-based plan, probably about $1,000 more than that, to anywhere from $2,000 to $3,000. And again, it's a little hard to tell prices because it depends on what the clients want. It's not typical for them to go up to the $6,000 range. That just depends on if someone wants to do some of that advanced planning. It also depends on whether someone wants us to help them title their assets to the trust. But my process is to do what I call choose your pricing. So I'll lay out 3 pricing options. I'll lay out some ranges, and we say, great, let's start with this. What interests you? Is this worth $1,000? Yes or no? And then we go through it. I basically tell clients when they sign on with me, again, it's not for the documents, it's for the experience, it's for the knowledge. And we ultimately just want to be there for your family when something happens to you. We don't want that scenario where your family comes to see us and says, what happens now? And we say, pay us thousands of dollars, and we get it taken care of. So the benefit of attending this meeting is, number one, is you do get that $500 fee is waived. The only thing that we ask for is just some commitments from you. We just ask that you complete the homework. So in order for us to have an effective family asset protection meeting with you, we ask you to tell us a little bit about you and some of your assets, and we just ask that you give that to us before your meeting. And the second thing that we ask for is that you not cancel or reschedule that meeting so close to the meeting time. We're a busy firm, and we're happy to help those, but it really impacts our schedule when someone calls us the day of or the day before to cancel, because we have other people who could have taken that slot. So as long as you're willing to commit to those 2 things, to do the homework and to not cancel or reschedule the meeting without sufficient notice, then we waive that $500 fee and you get a free asset protection meeting. And as an extra bonus, because I try and reward good behavior, if you call today and set up an asset protection meeting, then we also will give you a $250 credit towards your trust or wealth-based plan. We just don't put that $250 credit towards a will-based plan, but any of the other plans, you get $250 off if you call today and do it. We're about to open this to questions, so I'll just leave you with just some final thoughts. Again, I believe it's my job to educate and to see if we're a good fit for each other. Are these things important to you? If so, let's talk. And if not, then at least you have the peace of mind knowing what's going to happen with your affairs. If you do want to meet, then this is what it looks like. Is you can either call us, you can email us, or you can go to my handy link. Just make sure you mention this webinar. As long as you're registered, then you get that $250 off if you sign up today. So at this point, we'll go ahead and close. I just want to, of course, say thank you. And like I said, if you would like to sit down and talk about this more, let me know. Otherwise, I thank you for your time. I wish you and your family well, and best of luck in all your decision making. Thanks again. And once again, my name is David Taylor with Twin Falls Estate Planning.